Good afternoon. I'd like to talk to you a bit about employment discrimination. One of the most comprehensive laws dealing with employment discrimination is Title VII of the Civil Rights Act of 1964. And so we will spend a bit of time on that, discussing the general provisions, enforcement procedures, and the differences between disparate treatment and disparate impact. You will understand the specific types of discrimination prohibited by Title VII, and we will discuss employment practices that may be challenged. In addition, we will look at some other federal statutes that protect against employment discrimination, and we will briefly discuss state laws that may offer additional protection against employment discrimination. So Title VII. Keep in mind that it doesn't apply to very small employers. It applies to employers 15 or more employees and labor unions. The purpose is to eliminate job discrimination based on 5 categories: race, color, religion, sex, or national origin. But even in those cases where there is discrimination based on those categories, there are a few cases where employers can still have a defense or where the discrimination is permissible. And those are called bona fide occupational qualifications, BFOQs. A BFOQ would be if I discriminate against you based on your sex, but there is a good faith reason for that discrimination. For example, if a male applies to work in the ladies' dressing room at Victoria's Secret store, I could discriminate against him based on his sex because being female would be a BFOQ for that type of job. Also, if a Catholic priest applies for a job as a Baptist preacher, I could discriminate, or our church could discriminate based on his religion. However, certain things can never be BFOQs. Race and color cannot be a BFOQ no matter the circumstances. Now, enforcement of the Civil Rights Act is by the EEOC, Equal Employment Opportunity Commission. And they have the authority to hold hearings, obtain evidence, examine witnesses. 1991 amendments to the Act allow the recovery of compensatory and punitive damages for discrimination. And the EEOC must wait 60 days to act when state agencies begin discrimination proceedings. To file under the Act, the employee must file charges of illegal discrimination within 180 days. Now, proof. There are 3 different types of cases under the Civil Rights Act of 1964: disparate treatment, disparate impact, and retaliation. Disparate treatment is when the employer intentionally discriminates. So if you apply to be an attorney in my law firm and I say, no, I'm sorry, I only hire women, and you happen to be a male, that would be intentional discrimination against you based on your sex. If my law firm has 15 or more employees, then that could be, if my law firm, has 15 or more employees, that could be employment discrimination under Title VII. I've said I'm going to pick on you because you're in one of those 5 protected classes: race, gender, or color, religion, or national origin. That's disparate treatment. Now, disparate impact is a little more tricky. That is when there's a seemingly neutral rule. It's not a rule that says I won't hire any women at my place of work, but it's a seemingly neutral rule that says I will only hire people who can lift 100 pounds. That seems like a neutral rule. However, it has the discriminatory effect of making it so that mostly only men will be hired for the job, because statistics would show that men are more likely to be able to do that than women. However, there can be some excuses for that. Business necessity defense. So do remember that. So if the job is a job that involves lifting 100 pounds, then it might be okay for me to have that rule that you have to be able to lift 100 pounds, even though it might have a disparate impact of discrimination against females. However, if the job is simply answering phones or doing something of that nature that doesn't require the person to lift 100 pounds, then the business necessity would not work as a defense. Retaliation is also a form of violation of Title VII. This would be when an employee tries to make charges of discrimination or acts as a witness in a discrimination case against the employer or something like that. The employer might try to retaliate by firing the person or demoting the person or otherwise mistreating the person who's involved. And that is also illegal under Title VII. Discrimination based on race or color is one type of violation of Title VII. These could be discriminatory practices that involve recruiting, hiring, promotion, discharge, or application of the terms and conditions of employment. Violations that can happen. Permitting racial insults in the work situation, maintaining all white or all black crews for no reason, providing better housing for whites than blacks, giving higher Christmas bonuses to whites than blacks. You could also have disparate impact by saying, okay, I live in a city that's almost all white, and saying that only people who live within the city limits can apply for a job at my place of business, even though people right outside the city limits would be much more likely to be a diverse workforce. That could be disparate impact, a seemingly neutral rule that has the effect of discriminating in favor of whites. So discrimination based on race or color is one type of violation. So there can be intentional discrimination, but there can also be policies with disparate impact that are illegal. Examples of disparate impact: biased personnel tests, denying employment to unwed mothers, denying employment to people because they have a poor credit rating, giving priority to present employees when present employees are not in the minority. Those types of things can be disparate impact. They may seem to be neutral, giving a personnel test, but if statistics show that the pass rate for one group is much higher than another group, you need to be examining whether there is truly a business necessity for that test or whether it is just a way to discriminate. So, discrimination on the basis of national origin. Title VII protects various ethnic groups in the workplace. For example, speaking of a native language cannot be barred by an employer. So, for example, if an employer says employees cannot speak Spanish at our workplace during the workday, this may be discrimination on the basis of national origin. The only way that will work or be okay is if the employer can justify that speaking English is a business necessity. If it is not, this may be discrimination on the basis of national origin. Discrimination on the basis of religion is also prohibited. Now, of course, there is an exception for religious corporations, associations, or societies, such as churches. They can discriminate basis on religion. However, other groups cannot. So employers must give some reasonable accommodation to religious needs of employees. Now, that does not mean that an employee who works at a business that's open on Saturday, and if the business is Saturday is one of the busiest days, and so the employer needs the employee there on Saturday, that does not mean that that employee can have every Saturday off, to the detriment of all the other employees who also want Saturday off. So there are some limitations. It's reasonable accommodation, not unlimited accommodation. Discrimination on the basis of sex. Now, There are some statutes that say they're trying to protect women, but really those are sex discrimination. Rules requiring that airline stewardesses but not stewards have to be single. Policy of hiring only females as flight cabin attendants. A rule against hiring females, with preschool age children, but not against hiring males with such children. Those types of things will not be a defense, even though supposedly they are trying to protect women. Those do not give an employer a BFOQ in hiring standards. So you can't classify jobs as male or female. You can't advertise in the help wanted columns that are designated male and female. Another part of gender discrimination or sex discrimination is sexual harassment. One type of sexual harassment is quid pro quo, which essentially means this for that. If an employee is threatened with benefits or loss of benefits or promotion or job or whatever, based on whether or not the employee will give the supervisor a sexual favor, that can be quid pro quo harassment. It is quid pro quo harassment, and the employer is liable for that blatant type of harassment. There's a second type called hostile work environment. In those types of things, it would be coworkers making offensive sexual comments, showing nude pictures, that kind of thing. Employers are liable in those cases when the employer knows of the problem. It's a little different than quid pro quo, where the employer is automatically liable. This is when the employer knows of the problem and fails to take steps to correct the problem. There's also the Pregnancy Discrimination Act. Employers with health or disability plans must cover pregnancy and childbirth and related medical conditions in the same manner as other conditions. This covers married and unmarried women. There's the Equal Pay Act, which prohibits an employer from discriminating on the basis of sex when women and men are doing the same work under similar working conditions at the same business. Now, the discrimination is allowed if it arises from a seniority or merit system. All right, I'm going to stop here for a few moments, and I thank you very much for listening.